Good morning. We're going on the record. The time on the screen is 10:30 a.m. Today's date is Sunday, July 9th, 2000. We're located at the offices of Weil, Gottschalks, and Manges, 2882 Sand Hill Road, Menlo Park, California. This is tape number 1 of the deposition of Bruce Schneier. Case name, Universal City Studios vs. Corley. Venued in the U.S. District Court, Southern District of New York. Case number 00CIV0277. My name is Jason Butko, legal video specialist and notary, representing McMahon & Associates, 1 Elmden Boulevard, Suite 829, San Jose, California, 95113. The court reporter is from CompuScripts. The court reporter is Kim Menendrando. Counsel, would you please identify yourself, starting with the questioning attorney?
Carla Miller from the law firm of Proskauer Rose LLP in New York, New York, representing all plaintiffs.
Edward Hernstadt from Frankfurt Garbus, Kernert, Klein & Seltz, representing the defendants.
You may proceed. I'm sorry. Court reporter, can you please swear in the witness?
The jury is ready to please. Do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
You may proceed.
Good morning, Mr. Schneier.
Hi.
Oh.
Have you ever been deposed before?
Nope.
Have you ever testified in a court proceeding?
No.
Just so you understand, you're in a deposition, obviously. The court reporter seated to your right is taking down stenographically every word that's being spoken here in this room today, as among myself, you, and Mr. Hernstadt. Just as a matter of procedure, because the court reporter has to take down everything that you and I say, I'll try my best to make sure that I do not interrupt your answers with another question, and also if you could just make sure that if I'm in the middle of the question, you don't start answering until I'm finished with the question. Mr. Hernstadt, of course, will be here, and he'll be making objections, and again, if we could all avoid just talking over each other, I'm sure the court reporter would appreciate that, and we'll have a much cleaner transcript of everything that's said today. Are you currently employed, Mr. Schneier?
Yes.
And where are you employed?
A company called Counterpane Internet Security Incorporated here in San Jose.
And what's your role at Counterpane Internet?
My title is Chief Technology Officer. I'm one of the founders of the company.
And who are the other founders of the company?
The other founder is a man named Tom Rowley.
Tom Rowley?
R-O-W-L-E-Y.
And how long ago was Counterpane founded by yourself and Mr. Rowley?
The company was founded approximately a year ago.
Is it a public company?
No, it is not.
Are you a shareholder in the company?
Yes, I am.
Is Mr. Rowley also a shareholder?
Yes, he is.
Are there any other shareholders in the company?
Yes, they are.
Prior to founding Counterpane, were you employed?
Yes, I was.
Where were you employed?
I was president of another company called Counterpane Systems.
And where was Counterpane Systems located?
The company, it's a hard question. The company had 3 employees, and we all worked out of our homes. So the company was located in Illinois, although most of the people worked elsewhere.
Okay. When you say the company was located in Illinois, does that mean it was just incorporated in Illinois? Or
It was a sole proprietorship. It was just my company.
Okay. And were you living in Illinois at the time?
Yes, I was.
And who were the other 3 employees of Counterpane Systems?
The other cryptographers were John Kelsey, Chris Hall, and Niels Ferguson.
And how long was Counterpane Systems, excuse me, in existence?
I believe I formed it in 1993.
And was working for yourself with Counterpane Systems your sole employment from 1993 until about a year ago?
Yes, it was.
Prior to 1993, were you employed
Yes.
by whom?
AT&T Bell Laboratories.
And where for AT&T did you work?
Naperville, Illinois.
Midwesterner, huh? And how long were you employed by AT&T?
About a year.
And were you employed as a cryptographer?
No, I was not. I was employed as a systems engineer.
And prior to AT&T, what was your employment?
I worked for a company called Intelligent Resources Integrated Systems, also in Illinois.
Intelligent Resources,
Integrated Systems,
also known.
also in Illinois.
And what type of business is Intelligent Resources engaged in?
They made video hardware for Macintosh computers.
And what was your role in Intelligent Resources?
I oversaw operations.
What type of operations? The company's operations in general, or particular development of the video hardware?
Engineering operations, so development of the hardware and things associated with that.
Prior to Intelligent Resources Integrated Systems, what was your employment?
I worked for the Department of Defense in Washington, D.C.
And how long were you employed by the Department of Defense?
From 1984 through 1990 or 91.
And what did you do for the Department of Defense?
And that's classified.
Was it in the field of cryptography, or can you tell us?
It was in the field of communications.
Prior to working for the Department of Defense, was your employment?
That was my first job.
It's an ironic year to start.
Is that off the record?
Off the record, please.
Was this your first job after completing your education?
After getting my bachelor's degree, yes.
Okay. Where did you get your bachelor's degree?
University of Rochester.
Off the record. And you didn't go work for Kodak? Heck on. In what field did you obtain a bachelor's degree?
Physics. Off the record, that's why. On the record.
Very good. Did you obtain any other degrees after your bachelor's degree?
I have a Master's of Science in Computer Science from American University.
And what year did you receive your Bachelor of Science degree?
I received the degree in '85.
And what year did you receive your Master of Science degree?
86, I believe.
But you said you began working for the Department of Defense in 1984? Is that
Yes.
correct? So you began working for the Department of Defense while you were still in undergrad?
I finished all my coursework except one class, so I sort of graduated, started working for DoD, eventually graduated a year later.
I see.
So there's an overlap in the time, but not really in what I was doing.
Okay. In the course of obtaining your master's degree in computer science, did you take any courses in computer programming?
Yes.
Did you obtain any proficiency in any particular programming languages?
Any
I'm sorry, programming languages.
I did work in C and Pascal and Lisp.
Did you take any telecommunications courses in the course of obtaining your Master of Science degree?
I did not.
What is the current address for Counterpane Internet, your current company?
3031 Tisch Way, that's Tisch, Suite 100 Plaza East, San Jose, California.
And in what type of business is Counterpane Internet engaged?
We do managed security monitoring. We do internet security for organizations.
What does that entail, internet security?
What we do is we monitor our customers' internet networks against intrusions. So we provide basically a monitoring service where we will watch a customer's network and look for attacks, intrusions, and alert the customer.
So is it fair to say it's sort of like a burglary alarm service, a high-tech service for?
A burglar alarm is the kind of analogy we like to use.
And how many employees does Counterpane Internet have?
Approximately 100.
Now, apart from monitoring your customers' internet security, does Counterpane Internet provide any security, provide any security solutions for internet businesses?
Well, monitoring is in itself a solution. Detection and response, we feel is a solution to internet security, and in a lot of cases, a much better solution than prevention.
Okay. Does it provide any prevention solutions in terms of actual security systems products?
We don't provide products, we monitor other companies' products.
How many customers, if you know, does Counterpane Internet have?
We
Its
don't.
Customer base.
No, we don't release that number.
Okay.
Many of our customers prefer not to be named.
Okay, I'm not asking you for the names, I'm just asking for a customer base. But you said that you don't release the actual number
Yes.
of customers either? Do you have an up-to-date resume or curriculum vitae, Mr. Schneier?
The best is on my website. I don't have a paper copy with me.
And what is the URL for the website that you just referred to?
www.counterpain.com. Then follow the links to About Us, and then find my name.
Now, as I understand it, you've been asked to testify as an expert witness in this lawsuit. Is that your understanding?
That's my understanding.
Does your involvement in this case call upon any special skills or knowledge that you have?
I guess I don't know yet. I assume so.
Were you asked to provide any special skills in your testimony, or strike that? Were you asked to rely on any special skills that you have in providing your testimony in this case?
I was asked to talk about cryptography research. So presumably talking about that relies on my skill, on my knowledge and skills as a cryptography researcher.
And how long would you say you've been a cryptography researcher?
I would say in the academic arena, in the public arena, since 1992.
And what's involved in being a cryptography researcher?
A lot of mathematics. Would you say that that's the only skill involved, or specialized training that one would need to be a cryptography researcher? Cryptography is really a subset of mathematics. It involves a lot of mathematical disciplines. It also involves a mindset of making and breaking systems.
Now, if I decided that I wanted to be a cryptographer, what type of training would you advise me to undertake in terms of educational background, coursework in university?
There are sort of two areas I would advise. There are certain classes in mathematics. Some universities actually have specialties in cryptography, so you can take courses in cryptographic mathematics. There are other general mathematics courses that are useful. More importantly is to practice. It's easier to teach the mathematics than the mindset, but the mindset of looking at a system and figuring out how to break it, and then by learning how to break it, how to fix it and how to make it better. That's something you could really only learn through practice, through doing it again and again.
And how would you characterize that mindset, just so I understand? What sort of mindset is generally required?
It's a mindset of looking at systems and figuring out how to get around them. It's the kind of mindset that would walk into a building and look at the security system and say, I think there are some weaknesses here. It's a mindset of looking at a piece of mathematics and saying, this doesn't do what the designer thought it did. What the designer thought it did. So it's a mindset of looking for holes in systems. In cryptography, it's mathematical systems.
Is it fair to say that just one personality trait that might benefit a cryptographer is curiosity?
Curiosity is good. I've often been asked by many people, what does it take to be a cryptographer? And I did write an essay on this topic. It's on my website. It's called So You Want to Be a Cryptographer. And I talk about some of this. It's hard to quantify. When I did consulting, I would try to figure out who would be the right people to hire. I'm not sure there are traits I can point to and say these are the exact traits. I know it when I see it, but it's very hard to divide into components.
What did you look for when you were looking for people to hire, as you just testified to?
You just testified to.
Right.
people who had done it. What I was looking for as someone running a consulting company was not someone I could train, was someone who had already exhibited proficiency in breaking systems, in fixing systems, in cryptography, in mathematics, writing ability. A lot of what we're doing is writing papers and reports explaining what we've done. Good interpersonal skills, because we're often talking to people about the work we've done. So I looked for more finished products than people I could train.
Okay, so more experience. Now, you also mentioned that some universities have specialized coursework in cryptography. Does American University have specialized coursework in cryptography, if you know?
It did not when I went there.
Did the University of Rochester?
It did not when I went there.
Okay. Do either one of those universities now, if you know,
I
have
don't know.
specialized coursework?
I don't know.
What are the strike that? What are some of the universities that you're aware of that have specialized coursework in cryptography?
MIT does. University of California, I'm sorry, Stanford University. University of California, Davis. University of Waterloo. Cambridge University in the UK. L'École Normale Supérieure in Paris. A university in Belgium that I can't pronounce. And there are others.
When were you first approached about getting involved in the SWOT stuff?
Sometime in the spring.
In the spring of 2000?
Yeah, sorry, spring of 2000.
Do you have any recollection of what specific month?
I really don't. I mean, I'm sure it was before the before my signed document, so we can sort of work backwards from there.
And how were you contacted about getting involved in this case?
Either by phone or email.
You don't recall which?
No, I do not.
Who contacted you?
Some attorney.
You don't recall a name?
No.
Do you recall the name of a law firm?
Oh, that'd be even harder than the name of a person.
Was it Mr. Hernstadt?
It might have been. I actually don't remember.
You don't know. You say you think it was either by phone or by email that you were first contacted. If it was by email, would you have saved that email?
No, I would not have.
But you don't know if it was by email.
I don't remember. I really don't.
Do you recall anything about this initial conversation with the person you can't recall that asked you to get involved in the case? What was the substance of the conversation?
Yeah, I don't remember, but presumably I was asked if I would write a declaration.
And did you do that?
I did.
To whom did you send that declaration once it was written?
This was done by email, and I sent it to whoever the attorney was who contacted me, or whoever I spoke to afterwards.
But you have no idea
I don't
who this
remember.
was sent to.
I don't remember. It might have been Ed, but I actually don't remember.
Apart from the declaration that you've prepared and submitted in this case, have you prepared any other reports for submission to the court?
I have
at
not.
trial?
I have not.
Have you been asked to prepare any additional reports other than your declaration?
I have not.
As far as you know, will you be testifying in the trial of this case?
I believe I will be.
You have been asked to testify at trial?
We've talked about testifying.
Okay, who have you talked to about testifying?
Ed.
And when was the last time you talked to Ed about testifying?
I don't know, maybe a couple of weeks ago, last week, dates were being discussed, and I gave my calendar.
Okay. Trial dates or dates for this deposition that you're testifying in today?
Trial dates.
Are you being compensated for your involvement in this case?
I am not.
If you are to testify in the trial of this case in New York, has anyone offered to pay your travel expenses for going there?
And no one has.
Okay, I'm going to show you a document, Mr. Schneier. I'd like to first have marked as Exhibit 1. And once the court reporter's marked it, go ahead and show it to us. Please. Okay, if you can just take a moment and flip through the document and tell me once you've had an opportunity to look through it. You done?
Okay.
Have you ever seen this document before, Mr. Schneier?
No,
Ever seen a document that looks like this?
probably.
Okay. In connection with this case?
No.
Okay. So you have seen, you think, a subpoena before in your life, but not a subpoena directed to you for your testimony in this case?
That is correct.
Okay. Now, in preparing your declaration that's been submitted in this case, did you look at any documents or materials? And when I use the word document, I mean it in the broadest possible sense, like internet websites or web pages, DVDs, anything that you might have looked at in preparing the declaration that you submitted.
Yes.
Okay, what documents were those?
The declaration came out of an essay I wrote in November about the DVD copy protection scheme.
The DVD.
Copy protection scheme and the breaking of it that appeared in a newsletter I publish. So I relied on the essay I wrote to write the declaration. In writing the essay and the declaration, I looked at a variety of documents on the web, on the DVD copy protection scheme, on the DeCSS program, on the cryptographic algorithm, and on a variety of the politics associated with the system and its breaking.
Okay. Can you tell me specifically of those categories of documents that you just described, which documents in particular you looked at, or which internet websites one might go to look at those same documents that you looked at in preparing your declaration?
I can't. At the end of the essay I wrote in mid-November, I gave a list of URLs of documents I found particularly interesting or illuminating. So those I can produce. The other ones I looked at, I have no idea. I used a search engine, I followed links, I did my research online, and
Okay.
I only kept records of the stuff that I thought was particularly useful.
And those things that you found particularly useful in conducting your online research, those are the links that you just testified about, which would appear at the end of the essay that you wrote in November?
Yeah, it's not a complete list. I do a newsletter every month, and I write a number of articles on security topics, and at the end I like to give a list of links that the reader might want to follow. So this list is not the total of everything I found is interesting. It's a subset of what I thought the reader of the essay might find interesting, and links he might want to follow to get more information.
Okay. Mark this as Schneier too, please. Okay, Mr. Schneier, I've just, or the court reporter has just handed you what we marked as Schneier Exhibit 2. And it appears to be an article entitled DVD Encryption Break is a Good Thing by Bruce Schneier. It says special to ZDNet, and it dates, or it's dated, excuse me, November 16th, 1999. Is this the essay that you just referred to?
This is a similar essay. The essay I'm referring to appeared in my newsletter on November 15th. This is almost the same essay. There are some minor differences that appeared on the ZDNet website. This version does not include the links, and there are probably other minor additions or changes. I forget. I know they're not identical, but they're very similar.
Okay. And then the essay that appears on your Counterpane website in the November 15th edition of your newsletter, you're saying is the one that you actually looked at and relied upon in preparing your declaration in this case?
Yeah, that's the later one. This is, I believe this is an earlier draft of that, even though it appeared later. It was submitted to ZDNet earlier. You mark the third document. Come on. And Mr. Schneier, you've just been handed what's been marked as Schneier Declaration Exhibit 3, pardon me, Deposition Exhibit 3. Is this the declaration that you prepared for this case? Yes, it is.
And the date of this declaration, just flipping to the last page, is April 28th, 2000. Is that correct?
That's what it says.
Okay. So you earlier testified that you believe you were approached to participate in this case sometime before, obviously, the submission of this declaration. That looking at the date of the declaration, does that help refresh your recollection as to when you might have been first contacted about getting involved in the case?
Presumably it was before April 28th.
Okay. But you still don't know
I'm sorry.
whether it was 2 weeks before, 3 weeks before?
Yeah, I remember it being a pretty fast turnaround, but no, it was,
Okay.
it was probably not more than a few weeks before.
Okay. Did the person that contacted you about getting involved in the case, did they indicate that they'd seen your previous essay on the DVD encryption break?
I remember being contacted because of that essay,
Okay.
because the opinions in that essay were germane to the case.
Now, I want to ask you something about just the mechanics.
I'm sorry, I'm
of the-
having a hard time hearing you because you're gonna turn that way to look at your notes and then just move a little
Oh,
bit.
okay. Or I could get closer to you if you prefer.
Just stay in.
It is an odd angle.
Off the record for
Better
a second?
yesterday.
Karen, do we have to?
Absolutely.
We're going off the record. The time is 11:05. We're going back on the record. The time is 11:09. You may proceed.
Mr. Schneier, I believe we've just marked as Exhibit 3 your declaration in this case. Could you read back the last question, please?
Well, the last question was, did the person that contacted you about getting involved in the case, did they indicate that they had seen your previous essay on the DVD encryption break? Answer, I remember being contacted because of that essay, because the opinions in that essay were germane to the case.
Okay. Well, that's when we took the bath.
Well, actually, you said, now I want.
I beg your pardon?
Then you said, now I want, and then he wanted a break.
Okay.
I think actually that was the last question. Can I go to the bathroom?
No.
Operator.
Object!
Move to strike.
Okay. Okay, now I want to ask you some questions about actually how this declaration was drafted, Mr. Schneier. Did you actually type the declaration yourself?
I don't remember. I believe what happened was that one of the attorneys took my essay, put it in this form, numbering the paragraphs,
Mm-hmm.
and then I added stuff, deleted stuff, and made modifications based on what I wanted to say in the case.
Okay. So, the first time that you saw a draft of the document that eventually became your declaration, was that after the attorney had typed it up in the format with the paragraph numbers using the information in your essay?
One would hope the attorney wouldn't be dumb enough to type it. What I saw was my essay, the identical essay, just with the paragraphs numbered. So my assumption is that someone took the document off the web, didn't change words, put it in this format, and said, here, start.
Okay. But that's your assumption just based on, as you said, your view that no one would be dumb enough to just sit there and retype your essay?
And the fact that all the words were the same.
Mm-hmm. So you just answered my question for me.
I think that's my job.
You're right. Now, when you were first sent an initial draft of this declaration from the attorney, was that transmitted to you by email?
Yes, it
If you
was.
recall? Did you save that email?
I did not.
Did you save the document attached to the email?
I did not.
Do you recall at this point the name of the person that would have emailed you the document?
I don't. It might have been Ed, but I actually don't remember.
Once you got the email with the draft document, did you call anyone to discuss the draft?
I either called or sent email. Conversations did occur, either by phone or email.
But you don't recall one way or the other?
No, phone and email are pretty much the same in my mind.
Okay. But of course, you can't keep a documentary record of a phone call. Is that correct?
And you cannot, and I don't keep a documentary record of email.
How many drafts did this declaration go through before you finally signed it, if you recall?
I don't remember. Not very many.
5?
Possibly 5, possibly less. Probably not more, but possibly more.
So not more than 5?
Or maybe more than 5. I honestly don't remember. I mean,
Could it have
certainly
been-
not hundreds.
Could have been 10?
Probably not as many as 10.
Okay, so could have been more than 5, but probably not as many as 10.
Mm-hmm. Yes.
And you said that it could have been Ed that sent you the drafts of the declaration?
Yeah, I do not remember, but it certainly could have been him.
Mr. Hernstedt, if in fact it was you that sent the draft declarations or someone from your firm that sent draft declarations to Dr. Schneider, Mr. Schneider, I'd like to call for the production of those drafts if they exist at this time.
We will take it under advisement.
Thank you. And of course, any emails that accompanied the drafts.
That accompanied the draft.
Any emails that accompanied the drafts. Do you recall, Mr. Schneider, over what period of time these drafts were transmitted back and forth between yourself and whomever you were sending them to? Was it a week?
No, I don't remember. Presumably it was a days before it was signed.
Days before.
It was signed.
When did you first hear about DeCSS?
Sometime between October 15th and November 15th.
How did you hear about it?
Oh, don't remember.
Was it over the internet?
Most likely.
Do you know whether it was on a news-oriented website or a chat room?
Wouldn't be a chat room. It might have been a news-oriented website. It might have been a personal email.
It might have been a personal email. What is your understanding of what DeCSS does?
Which one is that DeCSS?
DeCSS.
DeCSS. Okay. DeCSS is a program that removes the obfuscation and scrambling of DVDs.
Have you ever used DeCSS?
I have never used it.
Have you ever seen the source code for
I have.
DeCSS?
I have never seen the source code.
And how did you gain the understanding that you just testified to what DeCSS does, if you recall?
I read it off other people's writings and essays and research papers.
Do you recall any of the people's essays or writings or research papers that you read?
The only one that I recall, although they are the list of URLs in my essay is probably a good list, is the...
I'm sorry, that's the November 15th essay that's on your website?
I'm sorry, yes.
You indicated was the most complete
Yeah.
essay that you wrote? Okay.
There is one paper that was written by someone who actually did the cryptanalysis of the encryption algorithm.
Do you remember that person's name?
I do not, but if I saw it, I'd say, yeah, that's him.
Do you know the name Frank Stevenson?
That's him.
Thanks. Have you ever spoken with Mr. Stevenson personally, or did you just read something that he had written?
I just read that one thing he had written. I'd never heard from him before, and I have not heard from him since.
Okay. Had you heard of him before?
I had not heard of him before.
When did you first hear about CSS?
At the same time, I heard about...
Sorry, objection. This was facts, not in evidence.
Have you heard of CSS?
Yes.
When was the first time you heard of CSS?
At the same time, I heard of DeCSS.
This would have been sometime between October 15th and November 15th in 1999, as you testified.
That is correct.
That's it. Now, before that period of time, and by that period of time, I mean October 15th to November 15th, 1999, did you know anything about a security system put in place to protect DVD content?
I knew something that this was happening. I'd done some consulting for companies who had video content to protect. And so I was familiar with the class of systems, their security properties, how they might work, how they might fail. I knew nothing about the particular CSS system, exactly how it worked, and exactly its flaws.
What companies did you do this consulting work for that had digital content that you just testified to?
Counterpane keeps its customer list confidential.
But this was in connection with Counterpane Internet or Counterpane Systems?
This is in connection with Counterpane Systems. And this was several years ago, probably before the CSS system was developed.
Do you know when the CSS system was developed?
No, I'm guessing.
Okay, so you don't really know whether this was before the CSS system was developed?
No.
Do you have an understanding now of how CSS, or the Content Scrambling System, operates?
I have an understanding based on documents I've read, yes.
And what documents have you read to gain that understanding?
Again, documents I perused before writing my essay in mid-November,
Okay.
including that cryptanalysis paper we mentioned earlier.
Do you know who any of the authors of DeCSS are?
I do not.
Now, a moment ago, I believe you testified that it was your understanding that DeCSS removes the obfuscation and scrambling of DVDs. Are you aware of any other functions that it performs?
I am not.
Go. No.
Have you ever seen or examined the object code for DeCSS?
I have not.
Have you ever visited a website with the URL www.2600.com?
Yes, I have.
When was the first time you visited the 2600.com website?
I don't remember. It was several years ago.
So you were familiar with the 2600.com website before your involvement in this case?
Yes, I was.
Like that. That's like the
Have you ever met Mr. Eric Corley?
Yes, I have.
When was the first time you met him?
It was several years ago. I believe it was at a hackers conference. I do not remember which one.
Do you remember where the hackers conference took place?
Either in New York or Las Vegas, since those are the only two cities of conferences I've been to that are hackers conferences.
Would stand to reason then.
That's good.
Was that the only time you've met Mr. Corley?
I believe I've met him several times.
When was the last time you saw Mr. Corley?
Again, I don't remember. It was at some conference also.
Okay. Was it after this lawsuit was filed?
No, it was before that.
Okay. Have you spoken to Mr. Corley since this lawsuit has been filed?
I have not.
Have you exchanged any emails with Mr. Corley since this lawsuit's been filed?
I believe he sent me an email thanking me for the declaration, but
Eric.
I don't remember exactly.
Over. Got it.
Would you have saved that email if in fact he sent it?
I might have. Probably not, but possibly.
Okay. Mr. Hernstadt, if it is at all possible that Mr. Schneier saved that email, I'd like you to check. And if so, I'd like to call for production of the email between Mr. Corley and Mr. Schneier.
The email saying thank you for your declaration.
If I don't know that that's what the email says, I doubt that you know that that's what the email says. That's why I like the
That's what
email
Mr.
produced.
Schneier said it said. But we will take it under advisement.
Thank you.
Sure. Off the record, I guess he could have said thanks for the declaration, but you should know I'm guilty as heck, right?
That's why I asked. That's why I'm entitled to see it.
Good point, good point.
Or he could say, thanks for the declaration. I don't believe anything you said.
Yeah.
Go back on record.
Were you told anything about Mr. Corley's activities which gave rise to this lawsuit?
I was not.
Have you ever seen the complaint that was filed in this lawsuit by the plaintiffs?
I saw it, I skimmed it, I didn't read it.
How did you see it?
I believe I went to the web and found it.
Okay. Do you remember what website you found it on?
I do not.
How long ago did you skim the complaint?
Did you send the complaint?
Skim the complaint.
Around the same time I wrote the declaration.
Okay. Did you strike that? When was the last time that you visited the 2600.com website, if you recall?
I think a couple of weeks ago.
Our folk. Yeah. After. Let's end. Model up this.
Have you ever heard of the Digital Millennium Copyright Act?
Yes, I have.
Did you at any time, Mr. Schneier, testify before Congress in connection with the legislative process involved in enacting the Digital Millennium Copyright Act?
I did not.
Did you write any essays during the time that Congress was considering passing the Digital Millennium Copyright Act, expressing a point of view about that law?
I did.
And if I wanted to find those essays, where would I go to find them?
They would be on the Counterpaint website in the cryptogram archives.
When was the Digital Millennium Copyright Act passed, if you know?
I do not remember.
Okay.
Do you remember? if you could refresh me with that date, I could put other things in context.
So if I were to represent to you that it was enacted in 1998, would that seem consistent with your recollection in terms of a general time frame or how long ago?
Yes.
Okay. So if we proceed on the assumption that it was passed in 1998, that's fine for you?
Yeah.
Okay.
Actually, do you have a month?
Oh, now you're testing me. I believe it was actually October or November, late 1998. Now, did you review any drafts of the Digital Millennium Copyright Act in conjunction with preparing the essay that you wrote about it?
Yes, I did.
Did you ever review the final bit of legislation as signed by President Clinton?
Yes, I did.
Do you recall any differences between the draft legislation that you reviewed around the time that you wrote your essay and what was finally enacted by Congress?
I believe there were several differences, and I reviewed several different drafts. And I probably wrote several different essays.
Okay. The first essay that you wrote about the Digital Millennium Copyright Act, did you express any concerns about the act and its provisions and how that might impact people that do the type of work that you do? By that I mean encryption research.
No, I do not remember the contents of the essays. I would have to look them up to refresh my memory. It is likely that I would have expressed concern over the act and the stifling effect that it would have on cryptographic and security research.
And what, in your view, was that stifling effect at the time that you wrote the the essay?
The act, because of its prohibition against circumvention and reverse engineering, would serve to limit the research cryptographers and computer security scientists could do. It would limit their ability to analyze systems, to study systems, to learn from systems, and to teach others about the security of systems.
Let me just intercede at one point that Mr. Schneier is testifying from his personal opinion and his personal knowledge. He's not testifying as a lawyer.
I'm sorry.
No.
He's not testifying as a lawyer and about the legal meaning of the act, but merely his understanding, his personal understanding of the act.
I understand that. And just so you know, I haven't asked you any questions about what your legal meaning or what the legal meaning is of the act. I understand that you're not.
In the time period you're talking about, there's no actual law. These were just drafts.
Right. Right. Now, when was the last time you looked at the final legislation?
It was soon after it was passed.
Okay. From the time that you originally expressed concerns about, as you said, the prohibitions against reverse engineering to the final draft of the legislation, do you recall whether any of those prohibitions were removed?
I believe they were not. I believe wording was changed. But I believe basically the prohibitions remained. Again, I would have to refresh myself by looking at the actual law and the drafts if I could find them.
Mm-hmm. And the last time you said you looked at the final legislation as passed was shortly after it was passed?
Yes. Although if you showed me an essay I wrote between then and now that mentioned it, I certainly would not be surprised. I do not recall writing any such.
In the final version of I'm just going to refer to it from here on out as the DMCA because the Digital Millennium Copyright Act is quite a mouthful. In the final version of the DMCA that you reviewed after it was passed, do you recall seeing any specific exemptions for reverse engineering activities?
I don't remember. At some point during the process, there were exemptions for compatibility purposes. I forget if they were struck. I believe the exemption for research purposes is still there, but I remember it being very narrowly defined and the burden of proof put on the researcher. Again, I forget if this stayed or if it left. You know, unfortunately, when I was working on this and writing about this was a while ago, and I've since then forgotten. If I was to write about this again, I would have to refresh my memory.
Okay. Now, when you said the research exemption, were you referring to an encryption research exemption, or what type of a research exemption were you referring to?
It was either an exemption for crypto research or for security research, but there was an exemption for researching the effectiveness of these security systems, for which reverse engineering was prohibited.
I see. And in viewing the final version of the DMCA as enacted, and that research exemption that you just testified about, were you satisfied that your initial concerns in looking at earlier drafts of the legislation had been addressed?
I was
Object to the former question. It's vague. Go ahead, you can answer.
I was definitely unsatisfied.
And why were you unsatisfied?
Because I felt that the provisions in the law as it remained would still have the same stifling effect on research that I foretold when I first heard about the law and the provision.
And what, in your view, was that stifling effect?
What the law does, as far as I know, from my understanding, is that it makes it very difficult, if not impossible, to take an existing security system, reverse engineer it, study it, publish the results of that study, and thereby learn from the mistakes made by the people who designed it.
And how is the understanding that you just testified to derived?
The understanding of the mistakes, the understanding of the details of the security system are derived from learning how it works, studying how it works, and figuring out how to break it.
Was that what you were asking, or were you asking about an understanding of the DMCA?
I'll get to
Okay.
both.
Let me make a very delayed objection to the form of the question. That's being unclear.
I don't know that you're objecting to the question as much as the answer, but
No, the
I'll
answer-
ask another question.
No, the answer is fine, but that just made me realize that I thought you were asking something else, and then I realized the question could have been asking either. So,
Could you read back the witness's last answer, please?
The understanding of the details of a security system are derived from learning how it works, studying how it works, and figuring out how to break it.
Now, Mr. Schneier, my question actually was, how is your understanding of the research exemption in the DMCA derived?
My understanding back then was derived from reading it
Okay.
and talking to other people who were involved in lobbying and speaking about it.
Okay. Do you remember the names of any of the other people that you talked to that were involved in lobbying and speaking about it?
I do not. The CCIA, I forget what that stands for, was involved in lobbying, and I did have contact with them. And then, anybody else who's likely to talk about it at conferences I'm at, I'm likely to hear their opinions. And the EFF and EPIC are two organizations whose opinions, if they were written, I would have read. And presumably there were other people.
Okay. The CCIA and the EFF I'm familiar with. What is EPIC?
EPIC is the Electronic Privacy Information Center. They're in Washington, D.C.
And what does the Electronic Privacy Information Center do, as you understand it?
As I understand it, they do several things. They are a privacy watchdog against industry and the government. They do a lot of FOIA of different documents from the government and publish what they find.
FOIA, do you mean FOIA, Freedom of Information Act?
And yes, I do. They do a lot of testifying before Congress on privacy and start again. They did a lot of testifying before Congress on privacy laws, and they do a lot of education on privacy issues as they relate to computers and computer networks.
Bob. F.
Are there any professional organizations of cryptographers that you're aware of?
No.
Commissioner?
Yes, there are. The IACR, the IACR, the International Association of Cryptologic Research, is the international cryptography professional organization.
Now, in your experience, or to your knowledge, are there any ethical constraints on cryptographic research activities with respect to disseminating the results of encryption research on a particular system?
To answer the form of the question, it's a very vague and broad question. If you can answer it, please go ahead.
You asked me if I have any ethical constraints or if anybody has any ethical constraints.
I asked you first if anybody or if any organization that you're aware of issues ethical guidelines concerning dissemination of the results of cryptographic research activities.
Objection to form of the question is compound. If you can answer that.
Certainly the National Security Agency classifies cryptographic research, as presumably do the intelligence organizations of other countries, as presumably do the intelligence organizations of other countries around the world. Some cryptographers work for companies, and presumably some of the work they do is proprietary, not disseminated. And quite possibly cryptographers may or may not on their own initiative decide to publish. Certainly anybody using cryptography to commit a crime using the results of analysis to break into systems is likely not to disseminate his techniques. And there certainly could be other ethical objections that people might have.
But as far as you're aware, is there a standards-making organization that issues guidelines with respect to ethical considerations in cryptographic research?
Objection to form.
As far as I know, no standards body or professional organization or group of cryptographers or group of cryptographers has issued any standards of what shouldn't be published.
Okay.
The overriding ethic in the cryptographic community is that publication serves research and advances knowledge and is a good thing.
Now, Mr. Schneier, have you personally ever had occasion to crack an encryption algorithm that was developed by someone else?
Yes, I have.
Which ones?
There are literally dozens. I have dozens of academic papers on my website that break different algorithms. And I could provide a list, but it's easy to go to the website and look at the papers.
Can you give me an example of some of the systems that these encryption systems were designed to protect?
Most of them were academic systems, and they weren't designed to protect anything. They were just designed. Generally, most encryption algorithms are completely orthogonal to the way they're used. So an algorithm might be proposed, and it might be used in a variety of applications, none of which the proposer had any idea they would be used in.
Okay.
An example of one that was proposed and used in a particular system was an algorithm used in some digital cellular systems.
Digital cellular
Digital
systems?
cellular telephone
For
systems.
telephones, okay. And were you, strike that, excuse me, were you personally involved in cracking some of the encryption algorithms for digital cellular telephone systems?
I was a member of a group that did, yes.
Was this an academic group, or what was the group that was involved in cracking these digital cellular telephone systems?
It was a group of researchers. It was not part of a consulting project.
Okay. Were these all academics? I'm sorry, academics?
Objection to the form of the question. You don't understand, like,
Yeah,
answer.
it's a hard question because many people who are paid by companies engage in academic research. So if by academic means someone who is paid by a university, the answer is one of the members of our group was. If the question is, were these people active in the academic community, the answer is all of them.
Okay. How many people were in this group?
The paper was written by 3 people, although this is my recollection, and I would have to look at the paper to be sure.
Okay.
But I remember 3 of the researchers.
Is this paper on your website?
The paper is on my website,
Okay.
yes.
Now, did you, after cracking this encryption system that was designed to protect digital cellular telephone communications, design a computer program or software utility that would allow anyone else to then crack into the digital cellular telephone systems to exploit the weakness that you were able to uncover?
Could you repeat that question, please?
Now, did you, after cracking this encryption system that was designed to protect digital cellular telephone communications, design a computer program or software utilities that would allow anyone else to then crack into the digital cellular telephone systems to exploit the weaknesses that you were able to recover? That was
Able to uncover?
able to uncover.
Objection to the form of the question. It's compounded and it assumes lots of facts not in evidence. You can answer it if you can.
I personally did not. Our team did write demonstration software, both to test our hypotheses and to demonstrate to whomever needed to verify our results that they were correct. I do not remember how the software worked and exactly how usable it would be by other people.
Is this piece of software available on your website in connection with the research paper that's posted on the website?
It might very well be. The way to check is to go to the Counterpane website, go to the Counterpane Labs website, look at the CMEA button on the left-hand side. That's the name of the algorithm. Follow the link.
I'm sorry. Look at the CMEA button
On the left
left-hand
side of the web page, that's the name of the algorithm.
But I have on the left-hand side, then it's, what's after that?
On the left-hand side, M dash, that's the name of the algorithm, M dash, and follow the link. Sorry, I speak in...
But you said you don't know how useful the software utility that was developed might be to anyone else that might try to use it? Is that what you said?
Objection to the form.
I just want to make sure that I understand your answer. I really am not trying to misstate what you said.
Yeah, I don't remember. It was several years ago.
It's okay. Do you have a point of view on whether or not a person that's engaged in encryption research should, at the same time as that person disseminates the results of that encryption research, disseminate a tool that would allow you to exploit the weaknesses in a particular encryption system?
Objection to form.
I have an opinion. In a lot of cases, part of the research is writing the tool, and part of disseminating the research is disseminating the tool. Personally, there are many cases where I feel that writing a tool whose sole purpose is to attack and break systems is not a good thing. There are some instances where writing such a tool is the only possible way to get the problem fixed.
Mm-hmm.
So it's a very complicated issue. It's one I have written on in the past few months. There's an essay on this topic that I've written. This is a topic where my ideas are still in flux because it's a very difficult question.
I understand. You said that you can imagine that there would be times when it wouldn't be a good thing to disseminate a tool that's designed to exploit the weaknesses. Can you give some examples of, in your view, when it wouldn't be a good thing to do that?
Objection to form.
An example would be a tool that doesn't actually demonstrate anything new, that endangers life and limb, and that exploits a problem that can't easily be fixed. Are examples where I would question the judgment of the person who released the tool.
And in your view, in what instances would a problem not easily be fixed?
Objection to form.
In closed proprietary systems. So in systems that are not, systems on a general purpose computer.
You have to go a little bit
Sorry.
slower because you're starting to slur in.
Sorry.
Systems that are not on
Not on a general purpose computer are often much harder to fix than systems that are on a general purpose computer. A system in a closed system like nuclear command and control or a standalone ATM machine. These might involve widespread deployment of equipment across the country or across the world, which is very different than a version of a piece of software which could be updated relatively quickly. Again, I understand this is a gray line.
From your point of view, it's a gray line, or from the point of view of cryptographers generally?
From my point of view.
Okay. So is it fair to say that, you just said that your ideas about this are in a state of flux. So is it fair to say that at this point you don't have a fully formed view on in which instances disseminating a tool to exploit a flaw in a security system might be permissible, and in what instances it might not be permissible?
And it's
Objection
very
to form. In the state's testimony.
it's very much like the definition of pornography. I know it when I see it. Defining exactly what it is hard. And to bring to something, I think you said, I'm here more talking about security systems as opposed to the mathematics of cryptography. The mathematics of cryptography is really much more cut and dried, and that publication is pretty much always a good idea.
Publication of the actual encryption algorithm? I just want to understand what you mean when you say publication of the mathematics of cryptography.
Publication of the research, which if in mathematics is generally mathematical research, which is generally a paper that includes algorithms and equations and analysis.
Okay.
And that's sort of one end. The other end is analysis of working security systems, which would presume cryptography, but would include analysis of the software, analysis of the procedures, analysis of the usage.
Okay. And the last sort of line of questions that we've been engaged in here, I'm really more interested in your view about developing and disseminating particular tools that allow an individual to exploit a flaw in a security system that a person engaged in encryption research might have been able to uncover. Is your point of view on that still in a state of flux?
My point of view on that is still in a state of flux. I believe I have a consistent and coherent point of view, but exceptions and special cases are still arising. So my view is still being refined.
Okay, and the point of view that you just testified to, though, is more or strike that, analogous to, like you just said, pornography. You know it when you see it. So you know a bad exploit of a tool as opposed to a good one?
I'm sorry, could you repeat that question back, please?
Yeah, I'm sorry. That was not the most articulate question.
Do you want it to try again, or should I listen to it?
I can answer it.
Okay, if you can answer.
Don't answer until I hear it, because I
Okay.
want to make sure I
All right.
have some vague idea of it.
I should hear it again, too.
And the point of view that you just testified to, though, is more analogous to, like you said, pornography, is you know it when you see it. So you know a bad deployment of a tool as opposed to a good one.
Objection to form. If you can answer, go ahead.
You want to try it again?
No, I'd like the witness that he could answer the question, so I'd like to hear his answer, and then if I need to follow up, I'll do that.
I believe that's true, although it's not impossible that someone would show me a special case that I would have no idea of my opinion on until I thought about it a lot.
Okay.
Is this a good time to take two? For unstated reasons.
We're going off the record. The time is 11:56.
How are we doing?
We're going back on the record. The time is 12:05. You may proceed.
Mr. Schneier, I'm going to show you the document that I'll have marked as Exhibit 4 to your deposition.
Thank you.
Let's see.
Someone was anticipating this litigation in this extraordinary way. The date is 1956 up here.
Wow.
Goes to the sheet.
I was.
All that's on the records. Now, initially, Mr. Schneier, I'd like you just to sort of focus your attention on the first 2 pages of this document. But just so we have a clear record, I'll represent to you that this is a document that I printed from the Counterpane website. It is entitled Cryptogram. The date of the document is January 15th, 2000. It says by Bruce Schneier, founder and CTO, Counterpane Internet Security, Inc. And the initial article is entitled, quote, Key Finding, Attacks and Publicity Attacks, end quote. Now, Mr. Schneier, earlier in your testimony you referred to cryptogram. What is cryptogram?
Cryptogram is a monthly newsletter. It's a free email newsletter that I write and publish every month.
Okay. Is this document that I've just shown you, that's been marked as Exhibit 4, a copy of the monthly newsletter Cryptogram that you write?
Without examining every word of it, I assume it is.
If you could just take a moment to look at the first 2 pages of the document that I've handed to you, I'd like to ask you some questions about it. Just tell me whenever you're ready.
I'm going to need a couple minutes too.
Sure.
I'm ready.
I'm not.
I have the advantage of having written it this year.
Okay.
Okay.
Okay, Mr. Schneier, do you recognize this article in this newsletter, Key Finding Attacks and Publicity Attacks?
I do.
Did you write it?
I did.
Now, without me reading it word for word, can you tell us just generally what the subject of this article is?
The subject of this article is a particular situation that occurred in January when a company made a press announcement about what they claimed to be a vulnerability in an internet protocol, and uses that example as a jumping off point to discuss some of the pros and cons towards releasing information about vulnerabilities, releasing vulnerability tools, and makes a stab at trying to draw some conclusions about some of the issues you and I talked about earlier.
Okay. And what conclusion is drawn in this article about releasing tools that exploit vulnerabilities in security systems?
The objection, are you asking him to point out in the article where he draws a conclusion?
No, at this point, I'd like you to do it from, I mean, if it helps you to look at the article, that's fine. I mean, however you want to answer the question, if you understand the question.
So you're asking me to discuss my thinking at January 15th, not subsequent. What I say in this essay is that one of the ways to look at a tool is to look at the motivations of the person who releases it. Whether it's a tool that demonstrates a vulnerability in some useful fashion, whether it's a tool that simply allows someone without any skill to exploit a vulnerability, whether the person releasing the tool has any ulterior motives in releasing it. And that's one way to get some idea of whether it was a good thing or a bad thing.
Okay. And you say the ulterior motives that the person might have had in releasing the tool is one of the factors in your mind that determines whether or not the release of the tool is a good or a bad thing? Is that correct?
And that's what I said, yes.
Now, in this particular situation that's being described in this article, or the essay, excuse me, Key Finding Attacks and Publicity Attacks, was there a particular tool that was disseminated along with the press release of the vulnerability in the internet
It's
protocol? In the internet protocol?
It's unclear. At the time I wrote this, I believe there was. In subsequent conversations with the company that released the press release, they indicated that they did not release the tool. I do not know if a tool was released, how widely it's used, whether someone else took the research done and wrote a tool. So when I wrote this essay, I believe the tool was released by the company that released the press release, but I don't know if that's true.
Okay. At this point, do you know whether or not there was a tool released?
At this point, I believe the people I spoke to from the company, and they said that they did not release a tool.
Okay. Now, you cite other examples in this essay, and if I could just draw your attention to page 1, and there are several bullet points, and I'll just read the introductory phrase to the bullet point just so you have a sense of where I am. You say, this kind of thing is happening more and more, and I'm getting tired of it. Here are some more examples. Then bullet point 2.
Carl, before you do that, could you just read the first line of the sentence before that where the word thing is defined?
Where the
So
word
thing is defined, so we know what kind of thing we are.
Well, I think if I want to have that thing defined, I'll ask the witness to define it, Mr. Hernstadt.
All right.
Okay.
Then let me object to any question that comes out based on that it's vague, that the term is undefined.
Okay.
If you could look at bullet point 2 on page 1, Mr. Schneier, you indicate that, quote, some people at EI, that's lowercase e, capital E, YE, discovered a bug in IIS last year, completely compromising the product. They contacted Microsoft, and after waiting only a week for them to acknowledge the problem, they issued a press release and a hacker tool. Microsoft rushed a fix out, but not as fast as the hackers jumped on the exploit. EI sells vulnerability assessment tools and security consulting, by the way, end quote. Do you see that, what I've just read to you there?
I do.
Now, did you do any verification of the facts of EI's rushing out and issuing a press release and a hacker tool that exploited the vulnerability in this Microsoft product?
No more verification than reading documents and opinions and things other people had written.
Okay. And did you think at the time that you wrote this essay that those activities were a good thing to do by EI?
A lot of this is very situation dependent, and often my objections are not based on what was done, but based on how it was done. My objections in the EI instance were based on the fact that EI seems to me to have used the exploit and the publication of it as a publicity engine for their company, and not as a not as a way to fix the problem. So I have no objections to the research, to the publication of the dissemination, but the form of it was something I thought was not the best it could have been.
Okay. And the form of it that you're describing, was that just the dissemination of the hacker tool, or just the fact that they were using this whole incident to publicize their security services?
It was that they were using the incident to publicize.
Okay, but you have no problem with them disseminating the hacker tool that was designed to exploit the vulnerability that they uncovered?
Objection to form.
And again, this is very dependent on circumstance. Microsoft as a corporation will lie, will claim things that are true that are not true, will deny the fact that exploits exist. If you point out a security vulnerability, they will tell you you're wrong. And the only way to get Microsoft to fix a problem, a security problem, is to release a tool. So in dealing with Microsoft, as a researcher wanting to improve the security of systems, you have no choice but to release an exploit, because without doing that, the system will remain vulnerable.
You have no choice?
If you want to improve the security, you have no choice.
So if you want Microsoft to pay attention, you have no choice but to explore, disseminate a hacker tool that could exploit the security breach.
Objection to
Is that
form.
your testimony?
Historically, that has been the case.
And because, I mean, and again, I really am not trying to put words in your mouth, but I'm just trying to understand your answer. Because you made some statements about a particular point of view, obviously, that you hold about Microsoft. And based on that point of view about Microsoft, if the security breach is found in a Microsoft piece of software, then in your view, according to your testimony, it's acceptable to disseminate a hacker tool that exploits that vulnerability?
Objection to the form of question and the lack of definition of the terms used. If you can answer that, go ahead.
I believe, as a researcher wanting to improve the security of systems, that simply publishing an academic paper describing the vulnerability in a Microsoft system will not result in any improvement. And the quickest way to improve the security of the system is to release the tool, and to release the tool in a very public way so that Microsoft has no choice but as a company to fix the problem.
I don't suppose you'd be surprised if someone at Microsoft felt differently about that, would you?
The objection to the further question. Go ahead.
Very few things surprise me in this field.
Fair enough. Now, looking a couple paragraphs down in the same essay, Cameron. You say, here are some examples of doing things right. In the first bullet point, and I quote, the University of California, Berkeley researchers have broken just about every digital cell phone security algorithm. They are not profiting from these breaks. They don't publish software packages that can listen in on cell phone calls. This is research, and good research, end quote. Now, when we talked earlier about your activities in helping to analyze some of the encryption, strike that, flaws in some of the encryption and security algorithms for digital cell phone technologies, were you referring to this group of University of California, Berkeley researchers?
Yes, I was.
Is this the project that you were involved in?
A piece of it. There are many different cell phone security algorithms. There are many different cell phone security algorithms that this group has successfully reverse engineered, analyzed, and published. One particular algorithm, I was involved in the process. There were several others that they alone were involved in the process.
Okay. Now, you made the statement in this essay, this is research and good research. Now, what were you referring to when you drew the conclusion, excuse me, about what good research was?
Objection to the form of the question.
I was referring to the cryptanalysis work done by the group in breaking the algorithms.
Not the fact that they didn't publish software packages that can listen in on cell phone calls?
Objection.
No, I was referring to the research. And to me, the research in this case was the mathematical research on the algorithms.
If the University of California at Berkeley researchers had published software packages that listened in or that allowed a person to listen in on cell phone calls, would that still, in your opinion, have been good research?
Objection to the form of the question.
It would still have been good research. They would have done something additional to that, which I personally would question, but other people would not.
Okay.
But
you personally would?
Yeah, I would, if they did that, I might have called them and asked, why did you do this? And they might have had an explanation, and I would have said, I guess you're right. But I certainly would have thought twice if I saw that. Because in this particular case, that wasn't really part of the research.
I'd like to direct your attention now to the fourth bullet point in that same list that says, and I quote, Perfecto markets security against CGI attacks, end quote. What is CGI?
I forget what it stands for. CGI scripts are those interactive bits of code on web pages that let you type things into forms and submit them, allow you to type comments in, click on radio buttons or other things that make X's happen, things that don't bring you to a new web page, but that put little bits of interactivity onto a web page. I think it's computer graphics interface, but I might be wrong as to what CGI stands for.
Okay. I'm just going to continue on reading that same bullet point. Quote, although they try to increase awareness of the risks, they don't go around writing new CGI exploits and publicizing them. They point to other CGI exploits done by hackers with no affiliation to the company as examples of the problem, end quote. Now, based on the point of view that you've been testifying to, I assume that this would fall into your category of good research, is that correct?
Objection to form. That misstates the testimony of the witness significantly. If you can answer that, go ahead.
To me, this is an example of doing things right, as I said. Again, if there were no CGI exploits, Perfecto would have to release some to demonstrate that the vulnerabilities they're describing and fixing are real. However, because there are already CGI exploits that have been published, that have been disseminated by the underground community, Perfecto did not feel it necessary to create new ones that didn't demonstrate any new piece of research. If they learned a new piece of research, they might feel, and I might agree with them, that they should publish an exploit to demonstrate this new piece of research. But as long as they are fixing old problems, writing new tools to demonstrate the old problems, doesn't seem to add anything to the discussion.
Okay. And how are you using the word exploits there?
It's a term of art in computer security. An exploit is a program that makes use of a vulnerability to attack a system. So it demonstrates the vulnerability in a graphic way.
Now looking at the last bullet point, you say Steve Bellovin, B-E-L-L-O-V-I-N, and I hope I pronounce his name correctly, at AT&T Labs found a serious hole in the Internet DNS system.
DNS?
D as in dog, NS system. He delayed publication of this vulnerability for years because there was no readily available fix, end quote. And again, is this falling within your definition of good research?
Objection to the form of the question, dude. I don't think there's been a definition of good research. But if you can answer the question, go ahead.
Well, it's certainly not a definition, because I think the witnesses already testified that it's sort of a situational thing. So I don't mean to misstate your testimony when I say definition, but you've used the phrase and characterized certain things and activities as good research.
Right.
That's all I'm asking you about.
Okay, are you referring to where he says good,
Doing things right is what I did say.
doing things right?
Correct.
Up top.
Yeah, this is good research. Additionally, the research is finding the hole. The delaying publication is a decision independent of the research.
Mm-hmm.
And Steve, in this case, made a decision not to publish, but to keep the vulnerability quiet until the internet was able to deal with some of the problems he found. That was his personal decision. Now, other researchers would have probably made different decisions. And that's, in some ways it's good that he did it, in some ways it's bad that he did it.
Mm-hmm.
That's probably the toughest example of the 5 listed.
Okay.
That's the least obvious of the 5 examples listed.
Okay. Now, when you say that he delayed publication of this vulnerability for years because there was no readily available fix, now in your mind, is that one of the factors that should be considered in determining whether or not this is a responsible or a right thing to do in terms of publicizing the vulnerability that you've been able to identify?
Objection to form.
My personal opinion is that whether a fix is possible and how easy it is and how expensive it is one of the many factors that I would take into account before publishing.
Okay.
Second.
Now, it's a couple more paragraphs down in the same essay. I'd like to direct your attention to, it's actually 3 paragraphs down from the list of bullet points that we've just been referring to, that starts, quote, "and look at how it is released." The N cipher, lowercase n, capital C, I-P-H-E-R, release included a hacker tool. As the New York Times pointed out, internal quote, thus making e-commerce sites more vulnerable to attack and more likely to buy N-Cipher's products, end quote, and internal quote. Announcements packaged with hacker tools are more likely to be part of the problem than part of the solution, end quote. Do you see the sentences that I've just read to you, Mr. Schneier?
I do.
Okay. Now, I understand you previously testified that N-Cipher, I believe, indicated to you that they, in fact, did not publish a hacker tool. I understand that aspect of your prior testimony. But you seem to express an opinion at the end of these last couple of sentences that announcements packaged with hacker tools are more likely to be part of the problem than part of the solution. What problem were you referring to?
In the essay, I'm talking about the problem of bad computer security and whether a particular release of information, of tools, increases the problem of bad security or helps solve the problem of bad security by making security better. And in that sentence, I said that tools, if something is released with a tool, it is more likely, although I just mean that as more likely to be part of the problem. So it's more likely to result in bad security. Let's try that again. It's more likely to be a release that exacerbates computer security problems than a release that will fix it. Certainly it's not cut and dried. This is just one of the many things you can look at in trying to figure out whether something was good or bad. Well, that's probably too strong a word for it.
I know, and I understand, I appreciate this is a gray area that we're talking about. Okay. Okay. That's all I have at this time on this document.
Does that mean we're done?
No.
Oh.
Just with this document, I know, I'm at the same rush of like, wow.
Okay, thanks. Now, Mr. Schneier, have you personally ever notified the provider or the developer of a security system that you're interested in researching before engaging in that research?
I have not. The only possible exception is when I was hired as a consultant to research a system, in which case they would know that I was doing it, but it'll be under contract.
Okay.
If as an academic I engage in research, I have never notified an organization or a company first.
What?
Have you personally, after engaging in encryption research, ever notified the organization whose security system you were testing before disseminating the results of your findings?
I don't remember. I believe when I published an analysis of Microsoft PPTP, which stands for Point-to-Point Tunneling Protocol, I sent a copy of my draft paper to some colleagues at Microsoft before publishing. Although this is my best recollection.
Mm-hmm. And how long ago would that have been that you engaged in this research on Microsoft's PPTP?
I do not remember, but the paper is dated on my website.
This paper's also on your website.
Everything's on my website.
And why did you send a copy of your draft paper to your colleagues at Microsoft?
Professional courtesy. I was afraid that when the paper was released, they would be asked by their superiors to explain what was going on. And I wanted to give them the opportunity to read what I had written and have a little time to think about what a response would be.
Now, is that only because you knew these people personally?
Yes, that's true.
So if you didn't have this personal relationship with the people at Microsoft that you sent the draft to, you wouldn't have bothered to send the drafts of your research results?
I probably would have not have.
But why not?
Because the only benefit that would have served was to allow the Microsoft PR machine to basically spread propaganda about the results before they were released. It would not have helped the problem. It would have made it worse.
And how do you know that?
It's been historical. Historically, that's what Microsoft does.
Okay. But what about other companies whose security systems you've researched that maybe don't have that same historic response as Microsoft?
Right.
The one example that comes to mind is the Digital Cellular Consortium, and we did not alert them.
And was there a conscious decision not to alert them?
I don't know, remember if it was actually discussed. So I don't recall if it was a conscious or unconscious decision.
Okay. So you don't recall any discussions amongst the research group about whether or not the Digital Cellular Consortium should be notified?
I do not
Objection to
recall.
form.
You
I
don't?
I do not recall.
But in your mind, as a participant in that activity, you didn't strike that, you didn't think that there was any issue involved in not notifying the Digital Cellular Consortium before publishing the results of the research?
Objection to form.
I mean, certainly there were
I'm
issues.
sorry, before publishing.
The results of the research. Yeah,
Objection
I'm
to
sorry,
form.
we do tend to kind of keep talking
It's just
over
a
each
long-
other, and I
Digital Cellular
apologize.
Consortium takes me about 9 strokes. Sound, wait just a second, objection to form. Then did you have an answer?
I certainly do. Certainly there were issues, but we felt that the greater good would have been served by publishing, and that there was no benefit to alerting the cell phone manufacturers.
When in your mind would there be a benefit to alerting a particular corporation whose security systems you've been involved in testing?
An example would be if a flaw was found in a browser. That as a researcher you might go to the company, let's say Netscape, and say, we found this flaw, this is it, this is how it works, we're going to be releasing our findings in 2 weeks. Wouldn't it be nice if at the same time you could release an updated version of the browser? And there's an example where the researcher and the company affected could work in concert.
But in the example that you just cited, we'll strike that. Are there any other examples that you can cite apart from the one that you just gave us?
Probably, but none
Involving
come to
Netscape.
mind right now.
Okay. So if I understand your answer, it would be beneficial to notify the company whose security systems were being tested if in the mind of the researcher the researcher thought that the company and the researchers could come to some sort of an accord on how to fix the problem?
Objection before him. I think that misstates the testimony. You can answer if you can. Go ahead.
That's one of the things to consider. You know, will the vendor mischaracterize the research? Will the vendor work with the researcher to fix the problem? Are there any political agenda that the vendors might have? There are examples where security systems have been deliberately weakened because of government intervention. Right? Those are examples where dealing with the vendor beforehand wouldn't make any sense because in some ways the vendor was a pawn also. So that's one of the considerations. There's certainly many of them.
Say a pawn, you know, pawn of the government?
Yeah, pawn's probably too strong a word, but they were influenced by the government, possibly to deliberately weaken their systems.
Okay.
This has occurred many times in security.
And again, I don't mean to, you know, misstate what you just said, but I want to just have a better understanding of your points of view. But as I interpret what you just said, it sounds like a lot of the consideration depends on the vendor that's involved and from the researcher's point of view.
Objection before him. I don't think that accurately states the testimony either.
Some of it does.
Okay.
I mean, I'm hesitant to define percentages of what refers to what, but
Sure.
certainly that's one of the considerations.
Okay. How- Now, in your point of view, if there were a law that required a cryptographer to notify the owner, the provider of a particular security system that they were engaged in encryption research concerning, would you think that that would restrict your ability to engage in such research?
I think it would restrict it in a very large way.
How so?
A number of reasons. One, it presumes that the cryptographer knows who to contact. For example, a cryptographer might research an encryption algorithm, Blowfish, which is an algorithm I wrote, and I know that Blowfish is in over 100 products. And I know there are products that I don't know about that Blowfish is in. So if a cryptographer wanted to research Blowfish, it would be impossible for him to notify them all because he just wouldn't know who to notify. In any real system, the company being researched might say no, might not give him permission. And that would mean that he would not be able to do the research, which means we would not learn about the system, we would not learn about its weaknesses, and we would not be able to build better systems because of it. So putting the burden on the cryptographer to get permission is something he can't do, and two, likely to stifle research because permission might not be forthcoming, especially in examples where there are many companies using the same piece of cryptography and you need permission from everybody.
Just take 1 minute and allow the videographer to change the tape.
This is the end of tape number 1 and the deposition of Bruce Schneier. We're going off the record. The time is 12:42. Number 2, volume 1, and the deposition of Bruce Schneier. We're going back on the record. The time is 12:54. You may proceed.
Now, Mr. Schneier, in your last answer, you expressed a point of view about requiring cryptographers to seek permission before engaging in cryptographic research and how that might inhibit that research. Do you feel that the owner of a security system has the right to grant permission to someone who might be interested in researching that system?
Objection to the former question, and insofar as it calls for a legal conclusion.
Well, speaking morally and not legally.
Mm-hmm.
I don't know what the law says, but I believe personally the answer is no.
So a person that puts a particular security system in place to protect their copyrighted content shouldn't have any right to have people come to them and ask permission before engaging in encryption research or perhaps disseminating the results of that research to the extent that it might allow people to exploit vulnerabilities in that security system.
Objection to the former question is compound. It also is argumentative, and it's difficult. So
That's what objection is for.
yeah.
Again, personally and not legally, I believe the answer is got either no or yes, depending on which one.
sorry?
Either no or yes, depending on which one does not have to ask permission. I just forgot the question
Okay.
in all the objecting.
Could we read back the question
Thank
so the witness can understand?
So if a person that puts a particular security system in place to protect their copyright content shouldn't have any right to have people come to them and ask permission before engaging in encryption research or perhaps disseminating the results of that research to the extent that it might allow people to exploit vulnerabilities in that security system?
Yes.
I have to object also that it's unintelligible.
Yes, again, morally and ethically, personally and not legally, I believe that someone who fields a security system, fields a security system, is putting it out in public. And at that point, does not maintain any control over who analyzes it. That in fact, someone can analyze it without asking permission or asking permission before analyzing or releasing information as a result of that analysis.
Let's go off the record for a second.
We're going off the record. The time is 12:57.
Alan?
We're going back on the record. The time is 1:02. You may proceed.
Now, Mr. Schneier, do you know when, well, first of all, let's do this. Mr. Hernstad, I believe a colleague of yours, has just joined the deposition.
Yeah.
Could he please make an appearance or identify himself for the record?
Sure, this is Alon Levy from the firm of Huber Samuelson. I think the court reporter has my card already.
Mr. Levy, have you already been admitted pro hoc vice as an attorney in this lawsuit?
Yes, I believe so. It's the original hearing.
Okay. Thank you. Mr. Schneier, do you know when the CSS, the Content Scrambling System, was first developed?
I do not.
In the reading that you did in preparing the essay, the November 15th essay that you testified about, that was sort of the precursor to your declaration that you filed in this case, in any of the documents that you read in preparing that essay, did any of them indicate when the Content Scrambling System was developed?
It's certainly possible.
Okay. But you have no recollection from that reading when it was developed?
I do not.
Do you have any idea when DVDs were first introduced into the United States marketplace?
Well, I have some idea, but I couldn't give you a year.
Okay. If I were to represent to you that the Content Scrambling System was developed somewhere around the late 90s, approximately 1996, would you have an objection to working off of that time frame for purposes of further questioning?
No, that's certainly plausible.
Okay. Do you have any knowledge of United States export guidelines concerning encryption technologies?
I do.
And how is that knowledge derived?
Reading. Reading and conversation.
What, if you could tell me, have you read to gain an understanding that you have today about U.S. export guidelines on encryption technologies?
Everything that I saw on the topic.
Can you give us some specific examples?
No.
Journals, web pages?
Journals, web pages, articles, speeches, books, magazine articles.
Have you ever looked at the law yourself, the guidelines?
Yes, I
yourself?
have.
Okay. And what, do you remember the citation for any of the guidelines that you looked at? Was it actually the statute itself or the implementation guidelines?
Probably both. Parts of the statute were reprinted in one of my books, so I could go there and then tell you exactly what I read because I could tell you exactly what I reprinted.
You could tell exactly what.
What I read because I can tell you exactly what I reprinted.
And which book would that be?
Applied Cryptography.
And when was Applied Cryptography published?
The first edition was published in October of 1993, and the second edition was published in October of 1995. You'll find that the copyright dates of the books don't match that. That's because publishers often pay fast and loose with copyright dates.
Fair enough. And at the time of the publication of the first and second editions of Applied Cryptography, did you reprint the export guidelines in both the editions, if you recall?
I do not remember. I know they're in the second edition. I don't remember if they're in the
Okay.
first edition.
And in 1995, the publication date of the second edition, that actually reprints a current or then current version of the export regulations as you understood them?
Objection to form.
As I understood them at the time, yes.
You might want to establish when the book was actually published.
I thought we already did. Did you answer my question when the book was actually published?
I think so.
I thought so too. Thank you.
Oh. I thought you said that the dates weren't.
Wake up, Ed. Let's move on. I'm sorry. The second edition of the book, to your understanding, was published in 1995?
Yeah, in October of 95, even
Thank
though the
you.
copyright date says 1996.
Thanks.
I got the other way around. Okay, sorry.
Now, in 1995, when the second edition of Applied Cryptography was published, do you recall if there were any limitations on the length of encryption keys that were imposed by the U.S. export guidelines?
The export guidelines did impose, the export guidelines themselves did impose limits,
I'm sorry, did not
did not
impose?
pose limits,
I'm sorry, did not
did not
Okay.
pose limits.
impose or pose? I want to make sure I get the right word.
Impose limits. There were effective limits really based on hearsay and things that had been granted export versus things that had not been granted export. At that time, encryption algorithms with a key length of less than 40 bits were allowed export. Were allowed export, and encryption algorithms with key lengths greater than 40 bits were not, except for some special circumstances.
And do you have an understanding of what those special circumstances were?
Understanding is a bad word because the government went out of its way to make sure people did not understand the rules.
Did you have any knowledge about what those?
In general, if you were to design your algorithm so badly that the key length was irrelevant, you would be allowed to export things with a greater key length. But as I said, these rules were not well defined, they were not codified, they were not written down. You basically had to submit something and hope for the best.
Okay.
So people tended to err on the side of making systems lousy.
And Mr. Schneier, in your opinion, as a cryptographer, is it possible to design an uncrackable encryption methodology?
Objection to form.
Defining uncrackable as beyond the limits of our understanding of mathematics, yes.
Has any such system been designed, to your knowledge?
There are many systems in use today that are believed to be uncrackable. Unfortunately, in cryptography, you can't make mathematical statements, this is unbreakable. But you can say that with our present understanding of mathematics, this is unbreakable. And there are many algorithms of which the latter holds true.
Okay, so is it fair to say that it's more probabilistic? You can just express an opinion that it's more probably able to be cracked or less probably able to be cracked, given our current understanding of mathematics?
Probabilistic is also a tough term.
Objection to form.
Probabilistic is also a tough term because that's a term of the art in cryptography.
I see.
Really, what you can say is that a particular algorithm cannot be broken by any method we know, nor do we have any roadmap that might get to a method that would break the algorithm. Now, of course, you could end up being wrong, but cryptographers often have a pretty good idea of what is and isn't breakable.
Do you have any understanding of what's considered, or is there currently a standard for key lengths for encrypted data over the internet?
Objection to form.
There's no standard. There are a bunch of guidelines. In 1997, I believe, a group of about 9 or 10 very respected cryptographers, myself included, wrote a paper which talked about minimal key lengths for commercial security and looked at different key lengths and forward in the years as to what would be minimal security that's required. On the internet today, the standard algorithm, standard's a bad word, the most commonly trusted algorithm is something called triple DES, which has a
Trying to move it. Okay, good. The most standard.
algorithm is something called triple DES, which has a 112-bit key. The government right now, the National Institute of Standards and Technology, or NIST, is proposing a new encryption standard, and that will have key lengths of 112 bits, 192 bits, and 256 bits. Single DES, which is 56-bit long, is used in some very low security applications, but everyone knows that a key length of 56 bits is just not long enough to be any good for most applications.
For most
Applications.
Known not to be any good for most applications in terms of what? I mean, what's the basis for that statement that you just made?
The easiest way to break an algorithm is to try every possible key.
Is that what's called a brute force attack?
This is a brute force attack. It works against any
I'm
brute
sorry.
forced,
Brute, yes.
BRUTE hyphen force.
Then let's go back to that. That's what's called a brute force attack.
Attack, right. I'm sorry, I turned away again.
Yes, a brute force attack can be implemented against any algorithm, regardless of the math, regardless of how complicated it is, just by trying every possible key. It's always possible, it always works. The question you ask is, how long does that take?
Right.
How long will it take for a computer to try every possible key? And a 56-bit key, as of a few years ago, is commonly known to be possible to break. There was a very public
what
break
period of
against
time?
DES.
I'm sorry, there
sorry.
was a very public.
Break against DES, which used hardware that broke a 56-bit key in, I think, under a day. There have been distributed attacks on the internet that have broken a 56-bit key over the course of days. And of course, these numbers are getting faster as computing power increases.
Right.
That's good.
And what was the processing power of that computer that you just testified to, where it was publicized that it broke DES in under a day?
I don't remember. Going back to cryptogram, there is an essay which goes into all the details of the processing
And
that
what
was
time
used.
frame did that occur?
I don't remember. I would look in the index of back issues.
Was it a year ago? More than a year ago?
I believe it was 2 years ago that I wrote about it.
Nope.
Okay. I'd like to now turn to your declaration, Mr. Schneier. Now, on page 2 of your declaration, or I'm sorry, the pages actually are not numbered, but let's look at paragraph 2. It appears on the second page. You state, and I quote, "The entertainment industry knew, even as it implemented it, that the security system created to protect DVDs would be broken," end quote. What is the basis for you making that statement?
The system is so robustly and profoundly bad that it's inconceivable to me that an engineer could have designed it without knowing that it was flawed.
So that's just an assumption on your part based on the, as you said, the robustly and profoundly bad system that was put in place. In other words, you didn't speak to anyone within the entertainment industry to actually ascertain that they knew that the security system put in place to protect DVDs would be broken?
Which question do you want him to ask?
The
second
latter one.
Okay, no objection to that question.
No, I did not talk to anybody. It's like when if you see a screen door on a submarine, you don't need to ask.
I'm sorry,
If you see a screen door on a submarine, you don't need to ask whether the engineers understood that the submarine would sink. It just seems sort of obvious.
That the engineers that would put a screen door on a submarine would know that the submarine would sink.
Right. It's just inconceivable to me that someone could make, that would be an honest mistake.
But again, just to be clear, when you say the entertainment industry knew, you never had any conversations with anybody in the entertainment industry that actually confirmed that statement.
I did
Is that
Ask and
correct?
answer.
I did not.
Going on in paragraph 2, you say that, quote, "they," and I assume that the "they" refers back to the entertainment industry, "expected the internet to be used to distribute programs that assist skilled consumers to remove the copy protection on DVDs." Okay, let's stop right there. What is the basis for making that statement, Mr. Schneier?
Again, it was my analysis of the system, my analysis of the security properties of DVD and digital content, and what's inevitable for digital communication systems.
Okay, but that's not exactly the question that I'm asking you.
Try again.
You indicated that the entertainment industry knew that the internet would be used to distribute programs that assist skilled consumers to remove the copy protection on DVDs. I'm asking you how you knew that the entertainment industry expected the internet to be used to distribute these programs.
Objection, asked and answered.
It seemed obvious to me based on the way the system worked.
It seemed obvious to you that the entertainment industry expected the internet to be used to distribute programs such as DeCSS?
Yes. This has been something I have been saying for years, that this would happen. It's inconceivable to me that the entertainment industry could be that blind to the inevitability of this.
Wait, you've been saying this for years?
That, yes, that digital content will be distributed on the net, that programs that will defeat any copy protection scheme that could be designed will be made available, that it is impossible to fix this problem through content protection.
Okay, but just because you've been saying that for years, just because you've been saying that for years doesn't necessarily mean that the entertainment industry expected the internet to be used to distribute programs such as DeCSS, correct?
Objection, that's argumentative. If you can answer it, go ahead.
Yes, I mean, I'm really giving them the benefit of the doubt. I'm assuming that they're not stupid. I suppose it is possible that they were really, really, really dumb. It seems extraordinarily unlikely.
Okay, continuing on, well, I'll just restate that, or again, quote from paragraph 2. He said they expected the internet to be used to distribute programs that assist skilled consumers to remove the copy protection on DVDs and play and edit and open parentheses with great difficulty, end parentheses, copy them. Now, what do you mean by with great difficulty copy them?
Objection to form. It says what it says.
There's a lot of difficulties associated with copying DVDs simply because the availability of DVD writers, I mean, they're not common. A DVD has a lot of data, which is difficult to transport and store. So any intermediate form is difficult to deal with. So copying DVDs, irrespective of any copy protection, is something difficult to do because it requires specialized tools and hardware and software. It's not something, for example, my computer at home, I do not have enough storage to copy a DVD.
How much storage do you have on your computer at home?
I don't know, but less than 4-point-something gigabytes, which is what a DVD is.
Okay. And we'll strike that. Do you have any idea what standard home computer packages that are available in the consumer marketplace are being shipped with in terms of hard drive storage space?
Objection to the question. If you have any idea, go ahead.
I don't, but I can pull any magazine off the shelf at a bookstore and find out.
Okay.
Mr. Schneier is not being presented for anything remotely like that.
Good thing, too.
Would it surprise you to learn that a consumer can purchase, for example, from Dell Computers, a fairly low-end personal computer system with a 20 gigabyte hard drive?
Objection to the form of the question.
It would not surprise me.
Okay. You've already testified that you've never used the DeCSS utility, is that correct?
That is correct.
So, have you heard from anyone whether or not it's difficult to use DeCSS to copy movie files?
I have not.
Objection to the form of the question insofar as difficult is referring back to a prior question. Go ahead.
I have not.
Right.
I'd like for you now to look at paragraph 6 of your declaration, Mr. Schneier. In the second sentence of paragraph 6, you state, quote, instead, DVD software manufacturers were supposed to disguise the decryption program and possibly the playing program using some sort of software obfuscation techniques, end quote. Do you see the sentence that I just read?
I do.
Okay.
That one. Paradox.
What's the basis for you making this statement that DVD software manufacturers are supposed to disguise the decryption programs?
Asked and answered. Okay.
That was based on my reading of the of information about CCS or CCSS and
CSS or D?
CSS and DCSS, and my perusing of the various web pages and writings on the topic. That the different software players all used obfuscation techniques to try to disguise the working algorithm to make reverse engineering harder.
Can you tell me what specific documents you read to gain that understanding?
I cannot. I would start with the ones on at the bottom of the essay and work from there.
The November 15th essay that
Yes.
we talked about? Okay.
Right.
Now, are you aware of any efforts by anyone to reverse engineer a software-based DVD player prior to the development of DeCSS
I don't know.
to ascertain the CSS encryption algorithm?
Objection to the form. I think that's unintelligible.
Personally, I am not.
You understood my question, didn't you, Mr.
Hope so.
Schneier? Thank you.
Just quoting Mr. Cooper.
It's off the record.
Vaguely. Okay.
Okay. The next sentence you indicate, this is a technique that has never worked, colon. There is simply no way to obfuscate software because it has to be on the computer somewhere and is thus accessible to researchers, people engaged in reverse engineering, and the like, end quote. Now, do you have any idea of how the DeCSS utility was developed?
I do not.
And what is the basis of the statement that you've made in paragraph 6 in that last sentence, that there's simply no way to obfuscate software?
It's a mathematical truth.
Based on what principles?
Mathematics, logic, computer architecture. It's not a problem that can be solved.
What's not a problem that can be solved?
The problem of obfuscating software such that someone cannot reverse engineer it. You might be able to make it harder, but you cannot stop it.
But it is possible to make it harder through obfuscation, to reverse engineer software.
It's possible to make it more difficult, but there's a limit after which you can't make it any more difficult, and that limit is still a limit where it's possible to reverse engineer it.
Okay. But again, just so I make sure that I completely understand your answer, are these the same principles that you testified to earlier that, say, for example, in a brute force attack, that as long as you throw enough processing power at a problem and attempting to reverse engineer something, eventually, depending on how long, you'll eventually be able to break it or get to the solution?
Objection to the form of the question. I don't understand the question at all. Could you read it back, please? Hang on, I want her to read it back.
But again, just to make sure I completely understand your answer, are these the same principles that you testified to earlier? That say, for example, in a brute force attack, that as long as you put enough processing power at a problem to reverse engineer something, eventually, again, depending on how long you'll eventually be able to break it or get to the solution?
What principles are you referring to?
The mathematical principles that Mr. Schneier testified to earlier that go into a brute force attack,
Okay.
for example, in trying to crack an encryption algorithm.
No, they're completely different.
Okay.
The brute force attack principles are based on the blind and mechanistic trying every possible key.
Okay.
The blind and mechanistic trying of every possible key. In this case, this is not something based on a time-consuming computer run of trying possibilities until we
Okay.
find the right one.
Great. That's what I want to understand.
Okay,
Okay,
no.
what is it based on?
No, it's basically completely different.
Show us
And
what.
could you explain what it's based on?
In a computer, the code, the object code, must be intelligible to the processor. Otherwise, it can't actually run. So by definition, any obfuscation technique will, through the course of running the software, be unobfuscated, because otherwise the software could not run on the machine. At that point, after the software has been unobfuscated, a researcher or reverse engineer can intercept the stream.
I see what you're saying.
So it has nothing to do with a brute force attack. It's real time, and it's based on the inevitability of the processor needing
Okay.
to deal with the raw information.
So basically just analyzing the strings of zeros and ones that happen to be in the computer's register at that point in time and determining exactly
Right.
what software steps the computer's executing. I understand. Okay, but based on this testimony, is it your understanding that it's only through this process that a software engineer then would be able to understand, once the software has been, if you will, unobfuscated for purposes of having it run on the machine, that they'll be able to intercept that stream and understand
Objection to
what's
form.
going on with the software?
No, that's not the only way.
Okay.
That's
Is
just a
there
way
another
that
way?
always works
Okay.
and cannot be stopped. You can certainly analyze the obfuscated stream and understand the obfuscated stream. Sorry.
I just want to make sure we're not saying un and ob. I just want
Right.
to get the.
Obfuscated stream
Okay.
and understand the obfuscation techniques and sort of reverse engineer it that way.
Okay.
It's possible to build a system that automatically unobfuscates code. Again, after understanding the techniques.
Okay.
So I just use the example of looking at the code after it's been unobfuscated as proof that it's impossible to do it. And that always works. But there are certainly
and
other
again,
ways.
just to make sure I clarify, I don't want to interrupt your answer, but that's as the code is being executed by the machine in the first example that you gave.
Objection to the form that misstates the testimony.
Yes, if you're going to do this methodology that always
I'm
worked,
sorry, if you could undo.
if you were going to do this methodology that always works, which is looking at the code as it's being read by the processor,
Right.
that would be during execution of a legitimate program.
Okay.
But there are ways to reverse engineer code and obfuscation techniques that don't involve doing that.
Okay. Go off the record for a
We're
second.
going off the record. The time is 1:34.
I'm real-
We're going back on the record. The time is 1:41. You may proceed.
Okay. Mr. Schneier, just a couple of really quick questions. I just want to make sure that we've gone through in your testimony today. Now, have you ever personally been involved in any effort to reverse engineer CSS?
No.
Okay,
CSS, not DC.
that's correct, CSS. Now, looking again at paragraph 9 in your declaration. You state, finally, as a matter of basic computer and cryptological science, the DVD break, consisting of, among other utilities, DeCSS, is a very good thing. It is good research illustrating how bad the encryption algorithm is and how poorly thought out the security model is, and must be available to cryptologists, programmers, and others as a research and intellectual tool through the normal channels, including but not limited to posting it on the internet, end quote. Now, in that statement, when you say the DVD break consisting of, among other utilities, DeCSS, are you referring to DeCSS in its source code form or in its object code form?
I am referring to neither. I'm referring to it in general.
Okay. But you've earlier testified that you've never seen the source code for DeCSS, is that correct?
I have not.
And you've also testified that you've never seen the object code for DeCSS, is that correct?
I have not. I have testified that I have not.
Correct. Thank you. Okay. That's actually all I have at this time in your deposition, Mr. Schneier. Subject to the few document requests that I've made of Mr. Hernstadt, and if you don't mind searching for the emails that we've talked about that you testified to that you might have, I'd like to leave the deposition open in case there are any follow-up questions. I know Mr. Hernstadt feels differently, and he will so state that on the record, I presume.
No, you're welcome to state my position for me.
Okay.
Since we, depending
It's the
who's taking,
shortcut thing.
depending who's taking the deposition, we each say the same thing.
Okay.
But obviously, I think the deposition is concluded, and thank you very much, Mr. Schneier. Appreciate it.
I thank you for your time and your candor, Mr. Schneier.
This is the end of tape number 2 and the deposition of
Excuse
Bruce.
me, before you go off, could you just put on the record a stipulation about releasing the original so that I have that on the record to the witness? That way we'll be relieved of all our responsibility.
Let's do it for all. Let's do it for all three of them.
Okay. I mean,
Yeah.
just go ahead and do it.
On the record, because the trial is scheduled to start on July 17th, we've requested the court reporter with respect to the depositions of Chris DeBona, Barbara Simons, and Bruce Schneier to provide the originals immediately or as soon as they're completed for review and signing, and then those will be returned to the party that noticed the deposition. And we appreciate the reporter's willingness to assist us with this. Thank you.
This is the end of tape number 2 and the deposition of Bruce Schneier. We're going back off the record. The time is 1:45.